Thank you for visiting the Miltenberger Law Offices YouTube channel and our website. We are a proven criminal defense law firm in Nebraska with over 1,000 cases handled and over 12 years of combined legal experience. Our firm has created these audio articles to help educate you on your rights, protect your freedom, and help you achieve the best solution for the charges you are facing. If we are hired for your case, we will never back down, no matter the odds. Assault lawyer in Omaha, Nebraska. An argument, a shove, a punch, a bar fight that got out of hand, a disagreement between neighbors, a road rage incident, a misunderstanding. Sometimes that's all it takes for someone to end up facing assault charges in Omaha. Not every assault case involves serious injuries. Not every case involves a weapon. And despite what many people believe, Omaha assault charges don't always require physical contact at all. Whatever led to your arrest, an assault conviction can carry significant consequences, including jail or prison time, substantial fines, a permanent criminal record, and lasting effects on your career, reputation, and future. At Miltenberger Law Offices, we represent individuals charged with assault offenses throughout Omaha, Douglas County, and across Nebraska. Whether you're facing misdemeanor assault allegations or a serious felony offense, we carefully examine the evidence, challenge the government's case, and work to protect your rights every step of the way. If you've been arrested, charged, or believe you're under investigation for assault in Omaha, call 402-217-2267 or contact us online to schedule a confidential consultation with an experienced Omaha criminal defense attorney. Because being accused of assault is not the same thing as being guilty. What is assault under Nebraska law? Many people assume assault simply means punching someone. Nebraska law is considerably broader than that. Depending on the circumstances, assault charges may involve allegations that someone intentionally, knowingly, or recklessly caused bodily injury, threatened another person in a menacing manner, or caused serious bodily injury through the use of a dangerous instrument. The seriousness of the charge often depends on several factors, including the extent of the alleged injuries, whether a dangerous instrument was involved, the accused person's intent, the identity of the alleged victim, whether the incident involved domestic violence allegations, the defendant's criminal history. Some assault offenses are misdemeanors. Others are serious felonies carrying lengthy prison sentences. That's one reason it's important to understand exactly what prosecutors are alleging and what they actually have to prove. Types of assault charges in Omaha, Nebraska. Nebraska recognizes several different assault offenses, each with its own elements, classifications, and potential penalties. Understanding the differences can be important because not every assault allegation is treated the same under Nebraska law. First-degree assault. Under Nebraska Revised Statute Section 28-308, first-degree assault generally involves intentionally or knowingly causing serious bodily injury to another person. Serious bodily injury typically refers to injuries that create a substantial risk of death or cause significant long-term impairment or disfigurement. Examples may include gunshot wounds, stabbing injuries, severe head trauma, broken bones requiring surgery, permanent disfigurement. First-degree assault is a Class II felony, making it one of the most serious assault offenses under Nebraska law. Fortunately, serious injuries alone do not automatically establish criminal liability. Prosecutors must still prove every required element beyond a reasonable doubt. Second-degree assault. Nebraska Revised Statute, Section 28-309 generally addresses situations involving bodily injury caused with a dangerous instrument or injuries resulting from reckless conduct under circumstances showing extreme indifference to human life. A dangerous instrument is not limited to firearms or knives. Depending on the circumstances, prosecutors may argue that numerous everyday objects qualify, including baseball bats, glass bottles, motor vehicles, metal pipes, tools, other objects capable of causing serious injury. Second-degree assault is typically charged as a Class 2A felony. Like many felony assault cases, these allegations often require a careful review of witness statements, physical evidence, surveillance footage, and the surrounding circumstances. Third-degree assault. Most assault cases filed in Nebraska involve third-degree assault, Section 28-310. Generally speaking, prosecutors may allege third-degree assault when someone, intentionally, knowingly, or recklessly, causes bodily injury to another person, or threatens another person in a menacing manner. Many people are surprised by that second part. Actual physical contact is not always required. Depending on the circumstances, prosecutors may pursue assault charges based upon alleged threats if they believe the conduct meets the requirements of the statute. Third-degree assault is commonly associated with bar fights, sporting events, road rage incidents, neighbor disputes, workplace conflicts, arguments that escalate into physical confrontations. Not every argument becomes a crime. Not every shove becomes an assault conviction. The facts matter. Assault by strangulation or suffocation. Allegations involving strangulation or suffocation, Section 28-310.01, are treated particularly seriously in Omaha. These cases frequently arise in the context of domestic violence investigations, although they are not limited to domestic relationships. Because these allegations often carry enhanced penalties and significant collateral consequences, prosecutors typically devote substantial resources to investigating them. Medical evidence, photographs, witness statements, body camera footage, and expert testimony may all become important pieces of evidence. Assault on a peace officer. Nebraska law contains separate statutes addressing assaults committed against law enforcement officers and other protected public servants while performing official duties. First-degree assault on an officer, Section 28-929. Charged if a person intentionally or knowingly causes serious bodily injury to a peace officer. This is a Class 3 felony, punishable by up to 20 years in prison, a fine of up to $25,000, or both. Second-degree assault on an officer, Section 28-930. Charged when an individual intentionally, knowingly, or recklessly causes bodily injury to a peace officer, emergency responder, or correctional employee using a dangerous instrument while the officer is performing their official duties. This is a Class 2 felony, carrying a mandatory minimum of 1 year and up to 50 years in prison, and fines up to $25,000. Third-degree assault on an officer, Section 28-931. Charged when a person intentionally, knowingly, or recklessly causes bodily injury to a peace officer. This is a Class 3A felony, which carries a penalty of up to 3 years in prison, 18 months of post-release supervision, and a fine of up to $10,000. Assault on healthcare professionals. Healthcare workers, including nurses, physicians, emergency medical personnel, and hospital staff, may receive additional legal protections under certain Nebraska statutes. These allegations often arise in emergency rooms, hospitals, correctional facilities, and other medical settings where emotions may already be running high. These cases frequently involve competing witness accounts, surveillance footage, and questions regarding intent. Domestic assault. Many assault allegations occur between spouses, former spouses, dating partners, family members, or individuals living in the same household. Domestic assault, Section 28-323, cases often involve more than the criminal charge itself and can involve protective orders, firearm restrictions, child custody concerns, housing issues, employment consequences. If your case involves allegations of domestic violence, our firm also represents clients facing domestic assault and domestic violence charges in Omaha and across Nebraska. Assault charges involving weapons in Nebraska. One factor that can dramatically change an assault case is the alleged use of a weapon, or what Nebraska law refers to as a dangerous instrument. Many people immediately think of firearms or knives. The law is much broader than that. Depending on how an object is allegedly used, prosecutors may argue that a dangerous instrument includes firearms, knives, baseball bats, metal pipes, glass bottles, hammers, tools, vehicles, heavy flashlights, virtually any object capable of causing serious bodily injury under the circumstances. In other words, an object doesn't necessarily have to be designed as a weapon to become one under Nebraska law. What matters is how prosecutors claim it was used. When allegations involve a dangerous instrument, misdemeanor assault charges may quickly become felony offenses carrying substantially greater penalties. These cases often require a detailed examination of the alleged weapon, the nature and extent of the injuries, photographs, medical records, body camera footage, surveillance video, witness statements, whether the object was actually capable of causing the alleged injuries. Not every object identified by law enforcement automatically qualifies as a dangerous instrument. Likewise, not every injury automatically supports the felony charge prosecutors decide to file. Those issues frequently become central questions during plea negotiations, pretrial litigation, and, if necessary, trial. If your Omaha assault case also involves allegations that you unlawfully possessed or used a firearm, you may also face separate Nebraska weapons charges, each with its own potential penalties and legal defenses. Because of the significant prison exposure that can accompany felony assault allegations involving weapons, these cases deserve a careful review of both the facts and the applicable law, not assumptions based solely on the allegations contained in a police report. Assault versus battery. Is there a difference in Nebraska? People often ask whether assault and battery are separate crimes. That depends on the state. In some jurisdictions, assault and battery are separate offenses with different legal definitions. Nebraska approaches things differently. Rather than separating assault and battery into distinct criminal offenses, Nebraska law generally addresses conduct involving threats, bodily injury, and serious bodily injury through its assault statutes. So if someone tells you it wasn't assault, it was battery, they may be thinking of another state's laws. Nebraska has its own rulebook. Common assault allegations we defend in Omaha. No two assault cases look exactly alike. Sometimes the allegations involve serious injuries. Sometimes they involve little or no physical injury at all. And sometimes the police only arrive after everything has already happened, leaving prosecutors to piece together conflicting witness statements and incomplete evidence. At Miltenberger Law, we represent clients facing a wide range of assault charges throughout Omaha and across Nebraska, including cases involving bar fights, road rage incidents, domestic disputes, neighborhood disagreements, school and college altercations, sporting events, concerts and entertainment venues, workplace confrontations, fights involving multiple participants, self-defense allegations, alcohol-related incidents, assault allegations involving dangerous instruments. One common misconception is that police always arrest the person who started the fight. Reality is often far more complicated. Officers frequently arrive after the incident has ended. Witnesses may disagree, emotions run high, people exaggerate. Sometimes everyone involved has a different version of events. Our job is to investigate what actually happened, not simply accept the first version written in a police report. Omaha assault charges and potential penalties. The penalties for assault in Omaha and throughout Nebraska vary significantly depending on the specific charge, the alleged injuries, the use of a dangerous instrument, and other circumstances surrounding the case. Assault offense, first-degree assault. Nebraska Statute, Section 28-308, Classification, Class 2 felony. Possible penalties: 1 to 50 years imprisonment. Assault offense, second-degree assault. Nebraska Statute, Section 28-309, Classification, Class 2 a felony. Possible penalties: up to 20 years imprisonment. Assault offense, third-degree assault. Nebraska Statute, Section 28-310, Classification, Class 1 misdemeanor, generally. Possible penalties: up to 1 year in jail, a fine up to $1,000, or both. Assault offense, third-degree assault, mutual consent fight. Nebraska Statute, Section 28-310. Classification, Class 2 misdemeanor. Possible penalties: up to 6 months in jail, a fine up to $1,000, or both. Assault offense, assault by strangulation or suffocation. Nebraska Statute, depends on applicable statute. Classification, felony in many circumstances. Possible penalties, varies based on the specific charge and surrounding facts. Assault offense, assault on a peace officer or protected professional. Nebraska Statute, various Nebraska statutes. Classification, enhanced penalties. Possible penalties, depends on victim status, injuries, and applicable statute. Note: assault penalties may increase based on the severity of the alleged injuries, the use of a dangerous instrument, prior convictions, or the identity of the alleged victim. Every case should be evaluated individually. Can assault charges be filed, even if the alleged victim doesn't want to press charges? One of the most common questions our Omaha assault legal team hears is, if the other person doesn't want to press charges, will my case be dismissed? Usually, no. In Nebraska, criminal charges are filed by the government, not by the alleged victim. While prosecutors often consider the wishes of the complaining witness, the decision to continue or dismiss a criminal case generally belongs to the county attorney or prosecutor handling the matter. That means a case may continue even if the alleged victim wants the charges dropped. The parties have reconciled. The alleged victim refuses to testify voluntarily. The incident occurred months earlier. Prosecutors may rely upon 911 recordings, body camera footage, medical records, photographs, witness testimony, text messages, social media communications, statements made at the scene. In other words, a criminal case doesn't necessarily disappear simply because everyone wants to move on. Self-defense is sometimes the strongest defense in Omaha. Not every person accused of assault was the aggressor. Nebraska law recognizes that individuals may, under certain circumstances, use reasonable force to protect themselves or another person from unlawful force. Whether self-defense applies depends on the specific facts of the case. Questions often include: who started the confrontation? Was the force used reasonable? Was there an immediate threat? Could the confrontation have been avoided? What do independent witnesses say? Does video evidence support either version of events? Self-defense cases frequently require a careful review of body camera footage, surveillance video, photographs, medical records, and witness testimony. Sometimes those pieces of evidence tell a very different story than the initial police report. Common defenses to Omaha assault charges. Every assault case is unique. That said, certain legal defenses arise frequently in Omaha assault cases. Self-defense. If you reasonably acted to protect yourself or another person from unlawful force, self-defense may apply. Defense of another person. The law may also allow individuals to intervene when another person faces an imminent threat of unlawful force. False allegations. Unfortunately, assault accusations sometimes arise from personal disputes, divorces, child custody battles, neighborhood disagreements, workplace conflicts, or simple retaliation. Not every accusation is accurate. Mutual combat. Some altercations involve two people who voluntarily engaged in a fight. Those circumstances may affect how prosecutors charge the case and how it is defended. Lack of intent. Many assault offenses require prosecutors to prove a particular mental state. An accident or misunderstanding does not necessarily satisfy those legal requirements. Insufficient evidence. The government bears the burden of proof. You do not have to prove your innocence. Prosecutors must prove every element of the offense beyond a reasonable doubt. That is a much higher standard than many people realize. Mistaken identity. In fights involving multiple participants or chaotic circumstances, witnesses sometimes identify the wrong person. Surveillance footage, cell phone videos, and independent witnesses can become extremely important. Constitutional violations. If law enforcement violated your constitutional rights during the investigation, certain evidence, or even statements, may be challenged or excluded from court. Every assault case deserves a careful review of not only what allegedly happened, but also how the investigation was conducted. What should you do? If you've been charged with assault in Omaha, being arrested for assault can be overwhelming. 1 minute you're arguing with someone. The next you're being questioned by police, handcuffed, booked into jail, or trying to figure out what happens next. What you do in the hours and days following an arrest can have a significant impact on your case. Step 1. Exercise your right to remain silent. You have a constitutional right to remain silent. Use it. It's natural to want to explain your side of the story, especially if you believe you acted in self-defense or the allegations are exaggerated. Unfortunately, statements made to law enforcement often become evidence later. Provide identifying information if required, but avoid discussing the incident until you've spoken with an attorney. Step 2. Do not contact the alleged victim. Many people believe they can simply call the other person and clear things up. That is rarely a good idea. Depending on the circumstances, there may already be a no-contact order in place. Even if there isn't, phone calls, text messages, emails, and social media messages can become evidence. Let your Omaha assault attorney handle communication whenever possible. Step 3. Preserve evidence. Evidence disappears surprisingly quickly. Save anything that may be relevant, including photographs of injuries, videos, text messages, emails, social media communications, call logs, medical records, receipts, location data, names and contact information for witnesses. Do not delete anything, even if you think it may hurt your case. Context often matters far more than a single photograph or message. Step 4. Stay off social media. This advice couldn't be much simpler. Don't post about your case anywhere. Prosecutors routinely review social media accounts during criminal investigations. Something intended as a joke or an innocent comment may look very different when displayed in a courtroom. Step 5. Follow every court order. If you've been released from custody, carefully follow every condition imposed by the court. This may include appearing for all court dates, obeying no contact orders, avoiding certain locations, complying with pretrial supervision, abstaining from alcohol or drugs, surrendering firearms if required. Violating release conditions can create additional legal problems and negatively affect your case. Step 6. Be honest with your attorney. Your attorney can't effectively defend facts they don't know. Attorney-client communications are confidential, allowing you to speak openly about your case. Good facts, bad facts, embarrassing facts. Your attorney needs all of them. Surprises may be entertaining in movies. They're considerably less entertaining during a criminal trial. Step 7. Contact an assault lawyer as soon as possible. The earlier an Omaha assault attorney becomes involved, the sooner your defense can begin. Early legal intervention may help. Preserve surveillance footage before it is erased. Locate witnesses while memories are fresh. Protect your constitutional rights. Review body camera and dash camera footage. Challenge inaccurate witness statements. Begin building your defense immediately. Time matters. Evidence rarely gets better with age. Frequently asked questions about assault charges in Nebraska. Is assault a felony in Nebraska? Answer: it can be. Nebraska recognizes both misdemeanor and felony assault offenses. The classification generally depends on the alleged injuries, whether a dangerous instrument was involved, the identity of the alleged victim, and the specific statute prosecutors believe applies. Can Omaha assault charges be dismissed? Answer: yes. Depending on the facts of the case, charges may be reduced or dismissed if prosecutors cannot prove the allegations, constitutional violations occurred, witnesses are not credible, or the available evidence is insufficient. Can I claim self-defense in Omaha? Answer: possibly. Nebraska law recognizes self-defense in certain situations. Whether it applies depends on the specific facts, including who initiated the confrontation and whether the force used was reasonable under the circumstances. What if there were no injuries? Answer: an assault charge may still be filed in some situations. Certain assault statutes include threatening conduct, while others require bodily injury. The exact allegations determine what prosecutors must prove. Can I be charged if we were both fighting in Omaha? Answer: yes. Mutual participation does not necessarily prevent criminal charges. However, the circumstances surrounding the altercation may affect the charges, available defenses, and potential penalties. Will charges be dropped if the alleged victim changes their mind? Answer: not necessarily. Criminal cases are prosecuted by the state of Nebraska, not by the alleged victim. While prosecutors may consider the victim's wishes, They generally decide whether to continue the case. Should I talk to the police if I know I'm innocent? Answer: even innocent people can unintentionally make statements that prosecutors later use against them. Before answering questions about an assault allegation, it's generally wise to speak with an attorney. How soon should I hire an assault lawyer in Omaha? Answer: immediately. The sooner an attorney becomes involved, the sooner evidence can be preserved, witnesses located, and your rights protected. Why choose Miltenberger Law Offices as your Omaha assault lawyer? Every assault case has at least 2 sides, sometimes 3, occasionally 6. Police officers often arrive after the incident has ended. Witnesses disagree. Memories fade. Emotions run high. The police report is only one version of what happened. Our job is to uncover the rest of the story. At Miltenberger Law, we carefully examine witness statements, surveillance footage, body camera recordings, medical evidence, physical evidence, and every aspect of the government's investigation to determine whether prosecutors can actually prove their case. Because allegations are easy, proof is considerably harder. Whether you're facing misdemeanor assault, felony assault, or allegations involving self-defense, we'll work to protect your rights and pursue the best possible outcome. Talk to a Miltenberger Law Omaha assault lawyer today. If you've been arrested, charged, or believe you're under investigation for assault in Omaha or anywhere in Nebraska, don't wait to learn about your legal options. The sooner an experienced criminal defense attorney becomes involved, the sooner steps can be taken to preserve evidence, protect your rights, and begin building your defense. Call 402-217-2267 or contact Miltenberger Law online today to schedule a confidential consultation with an experienced Omaha assault lawyer. Because one heated moment shouldn't define the rest of your life. Miltenberger Law Offices is a leading criminal defense law firm serving the entire state of Nebraska. We are headquartered in Omaha and serve Douglas County, Lancaster County, Lincoln, Sarpy County, and all of Nebraska. We look forward to helping you with your criminal defense attorney needs.